how accused child murderer David has been under investigation for months by authorities? Well, we just learned some key details about the secret grand jury proceedings that we're hearing evidence in this case, and the defense is about to get a hold of some very important information. I am going to explain what all of this means for the man accused of brutally killing a 14-year-old girl. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. Okay, we have an update in our David coverage that we need to talk about. We just got a big behind-the-scenes sneak peek at what the prosecutors in this case, the Los Angeles DA's office, has been up to in this case over the past year. And I think it's pretty significant. Now, I'm curious what exactly this is going to mean for David, for his case, if the defense gets a hold of this information. I know I'm being very vague right now, but there's a reason for it. I want to get into it. Let me explain. Let me put it into context. So David, of course, is the romantic homicide singer currently charged with first-degree murder, continuous sexual abuse of a child under 14, and unlawful mutilation of human remains, all in connection with the death of 14-year-old Celeste Rivas Hernandez. Prosecutors allege that he was in a sexual relationship with her, that back on April 23rd, 2025, he allegedly lured her to his rental home in LA, stabbed her to death, allegedly watched her bleed out, and then reportedly took horrifying measures to conceal this alleged crime, all in an effort to keep her quiet about their relationship, to prevent her from coming forward and ruining his lucrative career. The special circumstances allegations in this case that carry heftier penalties, potentially the death penalty, murder of a witness, murder for financial gain, lying in wait. Prosecutors allege that he used a deadly and dangerous weapon, a sharp instrument, and prosecutors allege that he purchased all these things: a blue inflatable pool, chainsaws, a body bag, heavy-duty laundry bags, and that he dismembered her. He dismembered her body, that he made suspicious trips to the Santa Barbara County area, that he lied to friends and associates about the alleged smell of decomposition at his place. And we know that September 8th, 2025, that was the day after what would have been Celeste's 15th birthday, where her dismembered, decomposed body is found reportedly in the front trunk of a Tesla, allegedly registered to David at an LA tow yard. And at the tow yard, detectives apparently opened the Tesla's front storage compartment, find this black cadaver bag. It's covered in insects, and inside the bag, this is where they discover a severely decomposed head and torso. And then this plastic garbage bag, apparently beneath the black cadaver bag, is what contained the dismembered arms.
A motion filed in the case reveals that the investigative grand jury met on 17 separate days. That's not a tabloid headline. That's a line from a public court filing. And here's the image to hold on to for the rest of this video. 17 closed-door sessions. No cameras, no public seat. Spread across 4 months. The machinery of a prosecution quietly assembling itself in a room the public was never allowed to enter, while the public case against a man accused of killing a 14-year-old girl looked from the outside like it was standing still. David, the musician charged with first-degree murder, continuous sexual abuse of a child, and unlawful mutilation of human remains in the death of 14-year-old Celeste Rivas Hernandez, has pleaded not guilty. Every allegation described here remains legally an allegation, laid out in charging documents and pending a preliminary hearing. Prosecutors allege he was in a relationship with her, that he lured her to a rental property, stabbed her, and then took what investigators describe as extensive steps to conceal her death.
Her body was reportedly discovered months later in the front trunk of a vehicle registered to him at a tow yard, dismembered, decomposed, the day after what would have been her 15th birthday. Before we go deeper into what the records actually show, make sure you're subscribed to the Crime Infinity, because we don't just cover the story, we follow the evidence. Here's the first fact that should stop you cold. Prosecutors did not need a grand jury indictment to charge this case. California allows charging by preliminary hearing instead, a public process with cross-examination, with a defense that gets to see the state's evidence as it's presented.
Was found in the Tesla. I say all this now to get to the development, the update. We know there is a preliminary hearing set for July 21st in this case. This is the opportunity for the prosecution to present what they hope is enough evidence for this case to move forward toward trial. It's a low standard. It's a probable cause standard. Kind of see the same thing playing out in the Tyler Robinson, Charlie Kirk case, right? Is there sufficient evidence? Is there probable cause to support the charges for this case to move forward? Now, one of the other reasons this is a big deal is that the prosecutors in LA didn't have to do this. They could have gone the route of a grand jury instead of a preliminary hearing. In other words, they could have had a grand jury indict or formally charge David of the crimes that he's now facing. And remember, a grand jury proceeding is a secret proceeding, usually no input from the defense. Preliminary hearing is different, right? It's public. The defense can present witnesses. They can cross-examine the prosecution's witnesses. They can make arguments. The defense is getting an opportunity to see the prosecution's strategy here. And it's still a question of why prosecutors didn't get a grand jury indictment in this case. Does it mean that there wasn't a grand jury? No, there were grand juries. In fact, there were reportedly multiple grand juries hearing evidence in this case. And perhaps they were investigative grand juries, right? Not in panel per se to get an indictment, but to present evidence, to subpoena witnesses, to get documents, to lock in testimony from witnesses and help the prosecutors lay out their case. Not necessarily to indict, not necessarily.
Prosecutors chose that public path for the formal charges, but newly unsealed records confirmed something else was happening in parallel, behind closed doors, for months before those charges were even filed. An investigative grand jury convened not to indict, but to lock in testimony. Say it with me, because it's going to matter 3 times before this video ends. The paper trail was moving even when the public case looked frozen.
Are you surprised by how many times the grand jury met? I mean, is it common for them or several grand juries to meet for that many times over the course of several months? And I'm still not 100% if it was one grand jury or several grand juries, but when you see that amount of dates and that amount of times, is that surprising?
So not surprising if you accept the idea that this is an investigative grand jury, that they are calling in witnesses, that the prosecution wants to lock in their testimony. Maybe these are reluctant witnesses. Maybe they've got to go outside the state to get them, but they're building the case for the prosecution, and they're doing it sort of step by step. They're not taking it right to a preliminary hearing. That's coming later. And they could have indicted with one grand jury, but what they're doing is using the grand jury as an investigative tool. So in that context, it's not surprising to have multiple sessions, multiple meetings. You've probably got multiple witnesses coming in, dealing with the forensics, the medical examiner, all that kind of stuff. So not surprising in the context of building the investigative case.
Hold on to that, because we're about to walk through exactly what was happening in the silence. According to the unsealed scheduling records, that grand jury sat on 7 separate occasions across 4 months, November, December, February, and into late February. Testimony locked in under oath, witness by witness, while the public saw almost nothing. And this is where the timeline turns genuinely strange. The November sessions line up almost to the day with reports that the defendant had stopped cooperating with investigators and with a court order sealing the medical examiner's findings entirely, a security hold placed specifically to keep case details out of the press. 2 things happening in the same week. The flow of information to the public shut off, and the flow of testimony into a sealed room turned on.
You look at those dates, and I'm trying to put 2 and 2 together, right? So we know that September 8th is when Celeste's body was reportedly found in the Tesla, okay? But now you're looking at those November grand jury dates. November 2025, that was when it was reported that David was no longer cooperating with the investigation. We know November 21st, 2025 is when the court orders that the LAPD medical examiner's report and information on Celeste's death be sealed, that a security hold is placed to prevent any information from reaching the media.
Ask yourself this. If a prosecution is building a case loud enough to eventually try in open court, why does the most important month of that case happen in a room with no seats for the public at all? That's the ticking clock at the center of this story. Not a manhunt, a quieter kind of countdown. The gap between when evidence is gathered and when the public is finally allowed to see it. A gap that in this case stretched for months, while a sealed autopsy report sat finished, waiting. Because here's the second hard document, the medical examiner's report. completed according to the timeline in early December, but not made public until after the arrest, months later. The summary describes multiple penetrating wounds to the torso, consistent with a sharp instrument, injuries to the liver and chest cavity, and full-thickness dismemberment of the upper and lower extremities. The stated cause of death? Multiple penetrating injuries. The manner of death? Classified as homicide.
Grand jury dates, what do we know? Well, first of all, I remember that's when we first started hearing rumblings about a grand jury, by the way. But more specifically, December 9th, 2025, that is when Celeste's medical examination was reportedly completed, but it wouldn't be publicly released until after David's arrest. But that date's key. And by the way, just going to that report, you read verbatim from the summary portion. It says in part, quote, autopsy examination was limited by extensive post-mortem changes. There are 2 penetrating wounds of the torso with smooth edges that may represent sharp force injuries. The wound on the upper abdomen penetrates the liver, and the wound on the left chest penetrates one of the left intercostal spaces with disruption of the adjacent ribs' cortical surfaces. The left lung appears intact. The bilateral upper and lower extremities show full thickness dismemberment. Multiple other skin and soft tissue defects are present without apparent associated internal injuries. The etiology of these defects is not clearly apparent due to severe post-mortem changes. Post-mortem toxicology performed on liver tissue shows the presence of a low level of ethanol, which may be due to post-mortem changes or ingestion and does not appear to be contributory to the cause of death. Given the history and circumstances as currently known by me in the setting of the findings by examination, ancillary studies, and in the absence of other definitive causes of death, the cause of death is multiple penetration.
That document existed, completed, finished, sitting in a file during the exact same weeks the grand jury was hearing testimony behind closed doors. The paper trail was moving even when the public case looked frozen. Then comes February, and if you're looking for the month that tells you the most about what prosecutors were actually building, this is it. A witness, reportedly a close associate of the defendant, was arrested out of state for failing to appear, brought back, and put in front of the grand jury for roughly 30 to 40 minutes. That's a strikingly short window for sworn testimony in a case this serious. Short enough to suggest one of 3 things: an invocation of the right against self-incrimination, a narrow foundational statement, or an immunity arrangement that limited what needed to be said on the record at all. In that same window, the defendant's own family was subpoenaed to testify and fought it in court. They lost. A prosecutor told the court plainly on the record that a vehicle registered to the defendant's address had been found containing a dismembered body, and that the family should expect to be asked about that.
The manner of death is classified as homicide. Let's talk about the February dates, okay? So January 22nd, 2026, we know David's purported friend Neil Langston was arrested in Montana, allegedly at his mom's house, reportedly for failing to appear as a witness. It was reported that the local PD assisted the LAPD in this. February 4th, 2026, that's one of the key dates, right? TMZ reports that Langston appears in a Los Angeles courtroom, reportedly to testify before a grand jury, but only for 30 to 40 minutes. Raised a lot of questions that if that's true, what did he testify to? Was he granted immunity? Did he plead the fifth against self-incrimination? We know February 2026 also was a key month because that's when David's father, mother, brother had challenged subpoenas requiring them to travel to LA and testify, but a Texas court denied their petition. And notably, at a court hearing, Bennett Dodson, assistant DA for Waller County, told the court, "Don't think it's a secret to anyone at this point that Mr. David Burke is a musician who is quite famous, and this matter concerns a car that was registered to him at these witnesses' address here in Houston that had a dismembered, decomposing body in it. I would say if a car with a dismembered, decomposing body is registered to your home address, that is something you should expect to be questioned by the authorities about, and that's what this is, Judge." And we learn from these filings that there is, in fact, a murder investigation into Celeste's death and that David is the target. So now we have a better sense of the significance of these grand jury dates.
This is the second turning point, and it deserves the same refrain. The paper trail was moving even when the public case looked frozen. Not just moving, accelerating, right as the public conversation about this case had gone quiet. Now let's talk about what this actually means procedurally, because this is where speculation has to give way to hard evidence.
An investigative grand jury doesn't indict, it builds. It locks witnesses into sworn testimony months before trial, so that if a story changes later, on the stand, in a preliminary hearing, in front of a jury, there's a prior sworn version on paper to hold that witness to. For the prosecution, that's leverage. But it cuts both ways.
Yeah, no, that's exactly right, because the prosecution doesn't have to put on its whole case. This is the probable cause standard. It's low. They just got to get over that little bar of probable cause. You don't want to put on all your witnesses, but you've got to do just enough so that the judge who's presiding, sitting on the bench, can say, okay, you've established probable cause. And it also telegraphs a lot, not only to the defense, but also to the public. Remember, the prosecutors have to answer to the public, which is looking for answers in this case. And so prosecutors want to show, look, this is what we've done. This is what we've got. They don't have to put on everybody, but they just have to put on enough in a bare bones case that a judge will find probable cause.
Is there a chance defense looks at these grand jury transcripts and makes an argument that I've seen happen in other cases before and says, you know what? You misrepresented facts to the grand jury, prosecutors. You know what? You left out exculpatory information, exculpatory evidence, evidence tending to negate the defendant's guilt. And because of that, because of your shenanigans in the grand jury, these charges should be thrown out. Although, no, right? Because there wasn't a grand jury indictment. So I don't know. You tell me, is there anything they could use that to try to get this whole case thrown out?
Well, no, you're right. There wasn't an indictment. There hasn't been a grand jury indictment. Normally, if there was some prosecutorial misconduct or somehow the testimony was tainted, you'd use that to try to challenge the grand jury indictment. No such indictment here, but they do get these statements under oath, which theoretically could be a gold mine for impeachment, for cross-examination down the road. So not a bad thing if you're the defense on this case. But the prosecution wants to lock in witnesses, especially if they are, if they're squirrely, if there's some question about their testimony. They want to,
because those transcripts don't stay sealed forever. Under the charging path prosecutors chose, the defense is entitled to obtain them, which means every sworn word spoken behind those closed doors over 7 sessions is about to become something the defense can dissect line by line, looking for any deviation, any inconsistency, any gap between what a witness said in secret and what they say next in public.
To be clear, you, me, the public, the media, we will never see those grand jury transcripts, right? Or
yeah,
maybe,
we won't see them unless
maybe
for
at a
some
trial?
reason
I don't
something is
know.
attached to a pleading that's filed in the court, or sections come up. But what the prosecution has is a prior statement under oath by these witnesses. Of course, that cuts both ways for the defense too, because you've got potential impeachment material. But the prosecutors have decided they've got to use the grand jury to do their investigative work for them, lock in these statements, lock in these witnesses.
Why is this beneficial to the defense? Now that the defense is going to get these grand jury transcripts from all of these days, and again, I say at least, I don't know if there was other days of grand jury testimony. We'll talk about the specific dates. I mentioned it before. But now that they're going to potentially get the transcripts from these specific dates, why does the defense
2
want
bites
them?
of the apple.
What are
So
they
you've
going to
got
do with them? How is it
statements
going to help
under
their
oath
case?
in a grand jury by witnesses for the prosecution, and the defense is going to track them. If they testify, if these witnesses testify differently at a preliminary hearing, at a trial, the defense has prior statements that they can use to challenge them, to impeach them. So for the defense, it's certainly helpful, because if the witnesses deviate even slightly from what they've said, defense is going to pounce on it. So while there is a benefit to the prosecution, the defense is going to get all the witness transcripts. The defense is going to get to pour over them. And by the way, the defense is also getting to see the prosecution's strategy, their theories early on. So there is a benefit for the defense, rather than going, say, right into a prelim or just going right to the grand jury. The defense is watching.
That's the irony sitting at the center of this entire case. The very tool prosecutors use to build their evidence quietly is the same tool that now hands the defense a roadmap of every witness statement they'll have to defend at trial. There's one more document worth putting on the table, because it complicates the clean version of this story. Reports that more than a dozen employees at the medical examiner's office are under internal investigation for allegedly accessing case files without authorization. Inquiries that reportedly trace back to this exact case, following the premature leak of details about Celeste's death before the autopsy was ever officially released. That's not evidence of anything happening to the forensic findings themselves, but it is a documented crack in the chain of information, in a case where every sealed record, every closed-door session, every controlled release of information was clearly designed to prevent exactly that kind of leak from happening at all.
Before I let you go, I'd be remiss if I just didn't ask your opinion on this other big update in this case. I don't think I've spoken to an attorney about it, but I think it's interesting. So we reported it last week. NBC News reported that more than a dozen employees of the Los Angeles County Medical Examiner's Office are under investigation for allegedly accessing law enforcement investigation files without proper authorization. And there is a belief that this is specifically about Celeste, about her death. And we know that there was an unfortunate aspect about this where there was the premature release of details about her death before the autopsy report was even published. And NBC had reported that it may have been the Celeste case that prompted this probe by the Human Resources Department. You tell me your thoughts on this and how it could potentially affect the David case.
Right. It's a PR problem for the prosecution. It's an HR problem for the medical examiner. It's not an evidentiary problem. I mean, it's not going to have an effect. Of course, the defense may want to use this to argue change of venue. Big profile cases in LA do not get changed on venue challenges. Yeah, they've got to deal with it. It's unfortunate for the medical examiner. It's unfortunate for the prosecution, but it doesn't have any direct effect on the evidence.
Let me challenge you. Couldn't they say, I mean, the defense, I don't know if they would say this, but like, wow, what a sloppy office you're running over there. My gosh, if they're releasing premature details, how can we be 100% sure you guys know what you're talking about with respect to the autopsy?
Oh, I do it. Yeah, that's the card I would play. But I think at the end of the day, does it actually affect the chain of custody? Does it actually affect the findings? If they want to raise questions about it, sure. I mean, that's what you got to try if you're the defense team. But in the big picture, I think it's more of it's a PR problem that the prosecution has to manage. At the end of the day, is it going to have a direct effect? Of course, it's a possibility.
The paper trail was moving, even when the public case looked frozen. 17 days of sealed testimony, a finished autopsy sitting quiet for months, a security hold placed the same week the defendant stopped cooperating. A witness testifying for less than an hour after being arrested to compel his appearance. A family losing a fight to avoid the stand? None of that proves guilt. A preliminary hearing exists precisely because none of it has been tested in open court yet, and every fact here remains an allegation until a judge or jury says otherwise. But it does prove something else, something worth sitting with. For months, the most important developments in this entire case were happening in a room the public was never allowed into, while everyone on the outside was left checking for updates that weren't coming. If you want to follow this case the way it deserves to be followed, go look up the publicly filed motion referencing the 17 grand jury session dates. It's part of the court record. It's specific, and it's the single clearest window into
how long this case was actually being built before anyone outside that room knew it. Read it. Then tell us in the comments. When a prosecution spends months building a case in total secrecy before a single public charge is filed, does that serve justice? Or does it just delay the public's right to know what's actually being done in their name? If this case raised more questions for you than it answered, that's exactly what documents are supposed to do. Like this video, share it, subscribe to the Crime Infinity, and turn on notifications. Because the moment these transcripts become public, we'll be the ones walking you through exactly what they say.